federal judge just tore a hole in the National Firearms Act, and he did it without mentioning the Second Amendment.
The fight over the future of suppressors and short-barreled rifles just reached a historic and monumental outcome.
The architecture of federal regulatory power just suffered a catastrophic structural fracture in a courtroom in Texas, setting off a legal earthquake that could dismantle decades of firearm oversight overnight. Imagine walking into a federal building, being told that an entire compliance apparatus spanning generations is built on a constitutional illusion, and watching a judge hand down a 66-page legal dismantling of that system. In a sweeping and historic decision, United States District Judge Reed O'Connor, presiding over consolidated high-stakes litigation involving prominent entities like the Silencer Shop and individual plaintiffs represented in the Jensen case, has officially struck at the core of the National Firearms Act. This monumental ruling has issued a permanent injunction against the federal government's ability to enforce key registration, fingerprinting, and penalty provisions of the NFA for items carrying a $0 tax rate.
Federal court handling two consolidated cases dealing with the NFA and also the $0 tax has now essentially issued a permanent injunction against the enforcement of those NFA restrictions against the $0 taxed items.
The entire defense mounted by the Department of Justice rested on the assumption that federal authority is infinitely elastic. But the court just drew a hard line in the sand, ruling that without a functioning tax, the regulatory house of cards instantly collapses. To understand the sheer magnitude of what just unfolded, we have to look back at the legislative shift that created this constitutional ticking time bomb. Following the passage of sweeping federal legislation that zeroed out making and transfer taxes for suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons, dropping the cost from $200 straight down to zero, a profound legal paradox was born.
When they removed the tax stamp from $200 to $0, that effectively made the part of the NFA that requires you to register suppressors, SBRs, and SBSs irrelevant. It made it completely useless because the whole point of the NFA was to collect tax.
Historically, the United States Supreme Court upheld the constitutionality of the National Firearms Act strictly as an exercise of Congress's Article I taxing powers. The logic was simple and absolute. If you tax an item, you can regulate it. But what happens to the regulatory apparatus when the tax collector stops collecting revenue entirely? That exact question became the central battleground in the Northern District of Texas, where legal teams argued that a tax producing zero revenue ceases to be a tax at all, stripping the federal government of its underlying constitutional authority to demand compliance, background checks, and federal registration. Judge O'Connor's meticulously crafted opinion cut straight through the government's legal acrobatics with surgical precision. The court emphasized that an essential, non-negotiable feature of any constitutional tax under Article I is the actual raising of revenue.
Essentially, he found that if there is no revenue, that means there is no taxing powers. The court here emphasized that an essential feature of any constitutional tax is actually raising revenue. Once Congress zeroed out the making and transfer taxes, the NFA's registration scheme lost its sole constitutional anchor.
When Congress slashed the tax rate on suppressors and short-barreled rifles to zero, it inadvertently pulled the keystone out of the entire regulatory bridge. The federal government attempted a desperate pivot, arguing that the special occupational tax on firearms dealers could somehow retroactively save the individual registration requirements for everyday citizens. The court decisively rejected that lifeline, ruling that forcing extensive criminalized registration requirements onto private citizens to prop up a business tax wildly exceeds Congress's enumerated powers. You cannot stretch a taxing power to mandate federal registration on non-tax items owned by private individuals.
Judge also explicitly rejected the government's argument that registering individual firearms enforces the special occupational tax on firearms in their dealers. The court held that forcing extensive registration requirements onto everyday citizens to support a business tax exceeds Congress's enumerated powers, and he noted expressly that Congress cannot stretch its taxing power to mandate registration on non-tax items on private citizens.
Refusing to stop there, the DOJ trotted out its ultimate fallback weapon, the Commerce Clause. Government attorneys argued that interstate commerce powers could independently preserve the statute and keep the NFA enforcement machinery alive. But Judge O'Connor firmly shut that door as well, pointing out that Congress enacted these specific NFA provisions strictly under the taxing power and never once invoked the Commerce Clause when the legislation was originally drafted. Relying on recent Supreme Court jurisprudence limiting federal overreach, the The court ruled that the judiciary cannot simply rewrite history or import a brand new statutory purpose to rescue a failing government argument.
The government argued that in the alternative, interstate commerce power could preserve the statute here and keep the NFA a valid, legal process. Judge Hendricks firmly shut down that argument, ruling that Congress enacted these specific NFA provisions strictly under the taxing power, and they never invoked the Commerce Clause at all.
Because the plaintiffs achieved complete and total victory on structural Article 1 taxing grounds, the court explicitly declined to rule on the secondary Second Amendment claims, dismissing them without prejudice. This strategic move means those Second Amendment arguments remain fully loaded, pristine, and ready to fire in future appellate battles if needed. The immediate practical consequences of this ruling are nothing short of explosive, though they come with a tense, high-stakes timer attached.
The rabbi I met with tonight is a plaintiff in one of them, and in it he argues that the county is violating his Second and his First Amendment rights, and also that it's prohibiting Jewish congregants from protecting themselves amid a serious rise in anti-Semitism.
The permanent injunction explicitly prohibits federal agencies like the Bureau of Alcohol, Tobacco, Firearms, and Explosives, alongside the Department of Justice, from enforcing NFA registration requirements, Form 1 and Form 4 processing, fingerprint submissions, and non-compliance felony penalties against the plaintiffs, their commercial entities, associational members, and current or future customers. However, in a twist that heightens the narrative tension, Judge O'Connor stayed the enforcement of the final judgment for exactly 7 days. This temporary window gives the federal government a narrow runway to sprint to the United States Court of Appeals for the Fifth Circuit to request an emergency stay pending appeal. Legal analysts and court watchers universally anticipate that the DOJ will flood the Fifth Circuit docket immediately, attempting to maintain the status quo before the clock runs out. If the Fifth Circuit ultimately denies the government's emergency stay request, the permanent injunction will flashbang into immediate full effect for the parties involved, creating an unprecedented legal landscape. Such an outcome would trigger massive ripple effects across various state lines, throwing state-level restrictions and federal compliance protocols into a state of chaotic flux. The friction between federal administrative overreach and constitutional boundaries has never been more visible, and the next few days will determine whether this lower court victory holds its ground or faces a brutal uphill battle in the appellate courts.
Congress in 1934 knew they couldn't just walk up and ban a suppressor outright, so they taxed it $200, which was a couple months of pay for a working man back then. And to prove you paid the tax, you had to register the thing with the government.
Back in the old days, they had an armory, and if you had to get guns, everybody went to the armory and got their guns out of the armory. We've gone way far in the other direction, away from rationality. And, we've got an irrational president, we've got an irrational Congress. We're just not going to surrender. If we get to a legal point and we lose in court, we lose in court. But I'm not going to surrender protections for people just because we're dealing with folks who are irrational.
As this high-stakes legal drama unfolds, the foundational limits of federal power are being rewritten in real time, proving that the architecture of gun laws in America is standing on increasingly fragile ground. That's it for today, folks. See you in the next video.